Working with individuals who have disabilities can create some unique challenges for real estate licensees. The Idaho Real Estate Commission has invited attorney David Penny with Kosho Humphrey Law Firm to discuss some common issues licensees may face in their daily real estate practice. Welcome, David. It's great to be here with you today.
It's a pleasure to be here.
It seems like there's a lot of misunderstanding and maybe even some uncertainty when it comes to working with people with disabilities.
There sure can be.
Well, to help with this, we compiled a few situational questions we'd like for you to answer for us. Let's go ahead and jump right into those questions. Many brokerages are interested in helping make this process a good experience for everyone, but they aren't sure where to start. What can they do to make their services more available to people with disabilities?
That's an excellent question. Perhaps the single best thing an agent or brokerage can do is to have a very welcoming approach to people with disabilities. And it's really an approach to everybody because disabilities often are not obvious. And so an attitude of, how may I help you? What can I do for you today? And then having an open-minded approach to the response, I think, is very important. Under the law, the obligation that an agent or brokerage has really begins when someone makes a request for accommodation. And a request for accommodation is when someone asks for a variation or a change in a rule or a policy or procedure that the brokerage or agent might have, for example, in showing properties or conducting a transaction of some kind. When that request comes, the agent should be very willing to tackle that, kind of I wouldn't say that every request is a problem, but it presents something that the agent needs to give some time and some thought and some effort as to how you would overcome that. And the obligation under the law is to respond appropriately to reasonable requests for accommodation. And a request is reasonable if it meets three criteria. It does not impose an unreasonable administrative burden. It does not impose an unreasonable financial burden. And it does not put someone's personal safety at risk. There's not, I believe the language is immediate risk of harm to someone by accommodating the request that's being made by the person with the disability.
That's great advice, David. Using your approach, if a real estate agent receives a phone call from a person in a wheelchair who wants to see some homes, what should the agent do when the home is not wheelchair accessible?
Again, a very good question. One of the points that arises from that question is who should be determining the properties that are going to be shown to this client who in the phone call has indicated that they're wheelchair bound. And usually that's a decision best left to the client to let them decide what properties they want to see. And it's not a responsibility of the agent to look at the properties and decide what would or wouldn't work for somebody in a wheelchair. It's usually going back to that very welcoming approach of saying, how can I help you? And what can I do in my power as the agent to make this opportunity to view property a good one for you, one that you'll enjoy, one that will be complete. Because at the end of the day, it's to meet the needs of the person with the disability so that they have an equal opportunity as someone without a disability. They may say, I'll be fine, I can walk with a cane, and I'll be able to go up a flight of steps. That won't be a problem. Others perhaps not. And so using our test on what is or is not a reasonable accommodation, in this setting we could see a couple of things that might develop. One of them, the client might say, well, my expectation is that you'll take my wheelchair to the top of the steps and then you'll carry me up and put me in the wheelchair. That is not a reasonable request for an accommodation because it changes the nature of what a real estate agent does, and therefore it would be an undue burden to have to assume the safety of somebody and actually carry them up a flight of steps. Another alternative, though, maybe the person says, well, I've got my cane, I can go around on a limited basis, all I will need is for you to just offer me a stabilizing arm so that I have 2 points, one my cane and two your arm, and we'll be fine. An agent might say, well, that is a reasonable request. I'd be more than glad to do that. I do it with my grandmother all the time. And so they're very comfortable doing that to help them view a house where there might be accessibility challenges. In some situations, an alternative may be to videotape the inside of the house or the parts that are not accessible to the person in the wheelchair, so that they can look at them and see them. And of course, we all know today with our cell phones, you can shoot a pretty decent video that the person could then see. Simply because a house isn't accessible at the time they view it doesn't mean that they can't come back later if they purchase the house and modify it with lifts and ramps and various things so that the house may be their dream home after they're through modifying it.
So regarding what you said earlier about a reasonable or unreasonable request, who makes that decision? Is it the agent?
Well, yeah, it's the agent trying to decide, is this something that presents an undue burden, for example, or something that is a reasonable request. Just because a request requires more time or more effort or a de minimis expense doesn't necessarily make it unreasonable. It's when they're undue. For example, carrying somebody. That would be an undue burden. When it's a personal strain, places the agent perhaps at risk of injury, assuming a tremendous liability, trying to carry somebody, that would be unreasonable. And so it really is going to be a case-by-case assessment by the agent. The key for the agent is to try and help solve the circumstance, to knock down the barrier or minimize the barrier created by the disability.
Okay, so let's say, for example, that a deaf couple comes into a real estate office looking for a home. Is the agent required to hire someone to assist with sign language?
Well, we go back to that same approach that we had talked about before. The person who is deaf often would make a request for accommodation of some kind to help overcome the barrier that they might have. So the agent then has to make some decisions. What would be a reasonable approach to overcome that barrier? One of the factors certainly that would be considered is what is the cost of having the person who can assist with, for example, sign language. Another question is, well, what else could be done as opposed to having someone come in and actually help reduce the barrier that's created by the disability? For example, someone who is deaf can use visual means such as a shared computer screen or something in writing or photographs, that type of information, to be able to learn about a property or view a property. So in that setting, generally I would say no, you would not be required as an agent to incur an expense to go and hire somebody to sign for the deaf couple. If the transaction goes deeper though, they want to discuss the details of a transaction, make an offer on a property, and if there's minimal cost of having someone sign, it might help facilitate the transaction to actually have somebody involved. In that circumstance, it might be reasonable. Now, if you do hire the interpreter for one person, the question that I very often get is, does that mean I have to hire an interpreter for the next person and the next person and the next person? And the short answer is no, it doesn't. Each request for accommodation stands on its own, and the agent has to consider that request and what would be appropriate based upon the needs of that particular client.
Okay, David, so it seems like it might be a good idea when the situation justifies the expense. Would you recommend the broker create an office policy that addresses this?
While a policy by the broker isn't required, it might be a good idea to have a forward-thinking statement that expresses that the business and its agents are committed to working with people with disabilities. You're not required to adopt a policy. However, if you do, the policy should probably be created with the input from either a disability rights advocacy group or an attorney to make sure that it's correct under the law.
So as you know, a big area that people seem to have a lot of questions about is service animals. Let's say a salesperson has a prospect that brings a dog with him wherever he goes. He says it's a service animal, but he's never seen it do anything but sleep. He really doesn't want this animal shedding in the backseat of his car, so what does he do?
Well, one of the important points raised in the question is here the agent is suspect or questioning whether this person perhaps has a disability and whether they need the animal at all. And unless the agent has gone through some legal training or training through an advocacy group on how to correctly ask that question, the better course of action for the agent here would be to just go ahead and accept what they're being told by the client, that they have a disability and that they need the animal to come along. Under the Fair Housing Act, most people refer to animals as assistive animals because you not only have the trained service animal, but you also have a comfort animal. And a comfort animal doesn't require any special training. They are often used to help ameliorate the effects of a disability that could be something, for example, post-traumatic stress disorder. So the best approach is to accept the fact that this person needs to have the animal with them and then address what the accommodation is so that you can accommodate it or that you can even propose alternatives. Here, it's some inconvenience, but the fact that a request for accommodation is inconvenient doesn't make it unreasonable. So a towel or sheet could be placed on the seat where the animal's going to be. Other alternatives could be proposed. One alternative would be, we'll take the client's car. The animal's already familiar with that car and just ride along, takes care of the shedding issue. And then lastly, the agent and the client could travel in separate vehicles.
That was great advice regarding service animals. We also get a lot of questions about certain breeds. For example, one agent had a buyer with a Rottweiler as a service animal, and they made an offer on a condo. The condo association says that their insurance company won't insure certain breeds, including Rottweilers. What should the agent do in that situation?
Under the Fair Housing Act, someone in this situation, like the seller or the insurance company, doesn't get to place a breed restriction on the service animal that the buyer has. So in this particular situation, to enforce that or to take that position may be a violation of the Fair Housing Act. It's very important to talk about the role of the agent in this setting. Perhaps the best approach would be to talk to your client and advise them to get some advice on the Fair Housing Act from either an attorney or a fair housing advocacy group so that they learn what their rights are. You're neither the attorney nor an advocate for the client in this setting, and it's best to refer them to a source that can give them the complete picture. As we step back from this question, I just want to make the point that under the Fair Housing Act, and we talk about assistive animals that could be either service animals or comfort animals, we're not just talking about dogs. Those animals can be a wide range, and someone, whether they're a seller or an agent, cannot discriminate against a person who has a disability that needs an animal that may be a reptile or a bird of some kind. Dogs are just perhaps the most common in what we see, but it's important to realize that that service animal, that comfort animal, that assistive animal can be something other than a dog.
That sounds like a great solution for the agent, and thank you for the clarification on service animals in general. I'd like to switch gears now and end with a situation about marketing. A client's home has a ramp and other wheelchair-accessible features. She'd really like to market it to people with physical disabilities. I know that the fair housing advertising requirements are pretty tough. Can the agent market the property that way?
The short answer is absolutely, because the marketing requirements under the Fair Housing Act are to prevent discrimination against certain protected classes. People with disabilities are a protected class under the Fair Housing Act. So discriminating against them would be against the law. But it's not against the law to promote something that is a benefit or an attribute of a property that might attract people who have a mobility impairment, for example, from enjoying a particular property.
David, thank you so much for your time today. We've had a great discussion on accommodating reasonable requests, and you've given us some nice tips that will really help us all as we work collaboratively to make the home buying experience more accessible to consumers.
It was my pleasure.
As a part of this segment, a handout has been prepared that contains the key points from our discussion today, as well as information that can help to start a conversation with your broker and office.